Hello, five-star real estate agents. It's Monday, and welcome to another Deal Doctor live stream. I'm Eric Graham. We're going to be reviewing non-refundable EMDs. What is a non-refundable EMD, and are they really enforceable? And before we do that, we need to find out, first of all, what is an earnest money deposit? And an earnest money deposit or payment is a specific form of security deposit made to demonstrate that the applicant is serious and willing to demonstrate an earnest of good faith about wanting to complete a transaction. Basically, it's money paid to confirm a contract. Now, if the seller accepts the offer, the earnest money is held in trust or escrow. When the transaction is settled, then the deposit is applied to the buyer's portion of the remaining costs. If the offer is rejected, the earnest money is usually returned since no binding contract has been entered into. If there's a breach by the buyer, then the seller might be entitled to the EMD. And we use the term might because there's a lot that goes into an EMD dispute, which we'll also talk about. But before we get there, I want to find out, one, people ask, are EMDs required? And the answer is no. They are not required in a purchase agreement, but they help to get a seller accept an offer. So what is a non-refundable EMD? We're getting a lot of questions from agents. Hey, I want to write a non-refundable EMD clause. Well, let's talk about a non-refundable EMD. And it's an EMD payment or fee from one party to another for consideration for a purchase agreement or to extend an agreement or to extend a contingency, which we see quite often. Now, people ask, can parties agree to create a non-refundable deposit? The answer is yes. A buyer and seller can certainly agree that a deposit will be non-refundable. However, that should be clearly and expressly set forth in the purchase agreement. Now, how do we write a non-refundable clause in the purchase agreement? And the answer is it's difficult because a clause, there's not one clause fit all scenario. So people need to be very careful about what their intentions are when they're trying to write a non-refundable EMD and when it will be executed within the time frame of a purchase agreement. So generalizing a situation to try and make it one size fit all is extremely difficult. So my disclaimer is this. We recommend consulting your attorney to help you as an independent contractor to create such language on how to best serve your client. Now, let's look at some language that we can review for a non-refundable immediate release of an EMD. On the screen, we should be looking at the first slide, and it's a scenario that we are going to extend closing for a fee and have the EMD become non-refundable. So the language that we have here is that buyer and seller agree to extend the closing date from blank to blank. In consideration for the closing extension, buyer agrees to deliver blank dollars, let's just say $2,000, via a cashier's check made payable to the name of the seller. Now this is a money fee that's going to be paid directly from buyer to seller. It further states that buyer and seller hereby acknowledge the earnest money deposit retained by, whether it's a title company or broker company, is, in this case, $2,000 and shall become a non-refundable earnest money deposit and paid from the escrow holder above to the seller. If the buyer terminates or does not close on or before blank date through no fault of the seller. Now, if the seller terminates or does not close on or before blank date, then the earnest money deposit shall be credited to the buyer's purchase price at closing. So we have a situation here where we often see where we have a closing date set, and now all of a sudden the buyer needs more time. And the seller says, well, hey, I'd be happy to extend this contract, but now I want a non-refundable EMD. So this language in here does kind of address that, but I have a note here that says that the above situation that we just read gives a closing extension. It grants the seller an upfront fee to extend the closing and makes the EMD non-refundable if the buyer backs out. But what problems do we see with the language? Well, one, was the money paid to the seller needed by the buyer for closing costs? You have to understand certain reserves or capital or cash that a buyer has might be sitting in an account that the lender is aware of. And now they may have depleted some of that money, now creating a situation where they might not be eligible for that loan. So unfortunately, we now created a clause that could be potentially damaging to preventing the buyer from closing. Another situation in the language that we just read is, did the money paid to the seller now cause the buyer to have enough funds? We don't know. So we just need to be very careful when we start looking at language about non-refundable EMDs. Now, if it's a cash buyer, you don't have to worry about that. But if it's someone who has a bank loan, we may want to find out from that buyer's agent whether the money that they end up having as a non-refundable fee, if it will cause them to now not be allowed to get a loan. So let's look at another scenario about a non-refundable EMD. Now, this is making a non-refundable EMD after the inspection period ends. We might be seeing where buyers say, hey, look, we still want to do inspections, but you know what? After inspections, we're going to make our EMD non-refundable. So let's look here. So the language that we have here is buyer agrees to deliver an earnest money deposit in the form of a check, certified check, or cashier's check made payable to whatever title or broker company in the amount of blank dollars. And we're going to call that the earnest money. Now, unless the buyer terminates this agreement within the inspection period set forth in paragraph 13, or again, depending on your purchase agreement language, you can insert the paragraph that correlates to the PA. In this case, in the West Michigan Regional, it was paragraph 13 in inspection period, but it could be another number located within your purchase agreement. But it says here that the earnest money shall become non-refundable after the expiration of the inspection period. If buyer defaults, seller shall be entitled to retain the earnest money as liquidated damages, and in addition may pursue any and all rights and remedies available at law or in equity. So what we're setting this up to show that after the inspection period, if the buyer defaults, that the seller will be entitled to the earnest money as liquidated damages. But it's still giving that seller the right to sue that buyer for other actions. Now, we further go on in the slide that says that if the seller defaults, the buyer shall be entitled to a return of the earnest money deposit and to pursue any and all rights and remedies available at law or in equity, including specific performance. So if the seller were to terminate, the buyer would still be granted the right to sue that seller for specific performance to force them to sell that home. Now, if a lawsuit is commenced, the prevailing party shall be entitled to recover from the other party promptly after a demand all attorney fees and costs incurred in connection with the lawsuit. This is a very interesting language. It's known as a prevailing clause. The prevailing clause means that the party who loses in a court case, they will have to pay the party that also wins. So not only will they pay money to defend themselves, but they're also paying the other side who is the winner. It's called a prevailing clause. These clauses are not in many of our purchase agreements. I believe TAR does have prevailing clause language. So anytime you're looking at a lawsuit, it's important that agents read their purchase agreements to see if this clause is in there about prevailing party and who is going to be responsible for any attorney fees. Again, this language that we just reviewed only deals with non-refundable EMDs after the inspection period contingency was met. Now, we still have an appraisal contingency that hasn't been addressed, and we still have final loan approval contingency that has not been addressed within this language. So let's look at another scenario. We have an EMD that becomes non-refundable after inspection period, except if the seller fails to close. So there's language here that says, unless the buyer terminates this agreement within the inspection period set forth in whatever paragraph number, buyer shall be deemed to have waived the right to terminate the agreement, in which case the party shall proceed to closing in accordance with the terms hereof, and the earnest money shall be deemed non-refundable to buyer, except in the event of seller's failure or refusal to close on the purchase. This language can be very strict because basically we're saying that with this, that we don't care about whether the buyer has that appraisal contingency or loan. We're saying that if they don't terminate within the inspection period, that they've agreed that their EMD is non-refundable and they're moving forward. Someone may consider another scenario of a two-tiered deposit. We're seeing agents where a buyer can limit exposure by using a two-tiered deposit, where with the two-tiered deposit, the buyer makes an initial EMD at the time of the offer and then significantly increases the deposit after the expiration of the initial contingency period, usually after the expiration of the inspection period. So you have an EMD in the very beginning of the purchase agreement, and then there's also another portion of it that's added after the contingency period that can be drafted within your purchase agreement. So basically you're saying that once you get past the inspection period, where most deals end up failing, hey, buyer, we're going to force you to move forward, and your EMD will become non-refundable if you get cold feet or you want to change your mind later on down the road. One of the final scenarios that I have here, and it's an in-depth detail. This is where I'm saying where when attorneys start drafting such language as non-refundable EMDs, they really go into looking at the purchase agreement, looking at the buyer and seller's requirements. And in this scenario, I have language here, non-refundable earnest money. As used throughout this agreement, the term non-refundable earnest money means the portion of the earnest money that is applicable to the purchase price, but becomes non-refundable to purchaser as provided in this agreement, except in the event of. So in this case, a lot of times attorneys will do exceptions within a non-refundable EMD, except for a seller default, except for the failure of any closing condition herein, except for seller fails and it refuses to reasonably consent. And it goes on and on and on, because what the attorney is doing is they're looking at every single out. They're looking at inspection period contingencies. They're looking at appraisal contingencies. They're looking at loan contingencies. So what an attorney will do is they will spell out every single one of those contingencies and then explain whether someone is able to terminate under that contingency and still retain the EMD, or if that EMD truly will become non-refundable. And I'll send this, I'm going to send out my notes after this meeting for people to look at some of this information and language, because I just want you to understand that if your mind is spinning right now, good, because the non-refundable EMD is very difficult, and there's so many other nuances and contingencies that we might forget, and when is a non-refundable EMD triggered and when it isn't going to be triggered. So there is a new update that I put together that will be on the email later this afternoon. That is a non-refundable EMD that makes it non-refundable after the inspection period and appraisal period is over. I took the language from a couple of different attorneys. It looks like it's pretty solid, but we'll be sharing that with you so that you have something. And the biggest point that I want to convey to you as an agent right now is the question that comes up: are non-refundable clauses enforceable by the escrow holder? Well, the answer is maybe. And who's the escrow holder? It'd be your title company. It could be 5 Star, whoever's holding those deposits. Non-refundable clauses might be enforceable, but it depends on whether there's a dispute between the parties. Now, this dispute can be with or without merit, meaning once dispute occurs, the EMD will not be released until both parties agree, or it's sent to interpleader or the courts. So one topic comes up is, should agents write the non-refundable clauses on behalf of their clients? Probably not, unless you're an attorney or want to assume the risk. As an independent contractor, you might want to consider spending some money to hire an attorney to help you with your initial clause and to ensure proper legal counsel. Again, there are so many different scenarios, and there's no one clause fits all. I provided basic language, but I still would consider an attorney review your specific case, since, again, there's no one clause that fits all. I think It's going to depend on whether you want that non-refundable money to become after the inspection period, after the appraisal contingency, or even after the loan approval. So there's 3 different scenarios there. Now, who has the final say to release any type of EMD? Well, it's actually the buyer and seller have the final say, and they have to agree to it. The escrow holder, who is acting as a neutral party, will also have the final say. I mean, we can include language stating the seller will be awarded the EMD if the buyer fails to close, or either party, regardless of the merit, can dispute that release. So just because we put in the purchase agreement that something is non-refundable, we still need to have both parties agree to the release. So if both parties can't agree, then the escrow holder, who is the neutral third party, can interplead the deposit. Now, what does interplead really entail? Well, it's basically turning over the money to the courts. So if you have a title company and they have an earnest money deposit and they're holding that money, they may have separate contracts and agreements that both the buyer and seller will have to sign off on before the money is released, even though your purchase agreement says, hey, the money is going to be non-refundable and go to your seller. It doesn't matter. They have to follow a whole separate set of guidelines, and they are not responsible for determining whether a buyer and seller who cannot agree if this is with merit or without merit. They don't get the chance to say, okay, we're going to award this to the buyer, or we're going to award that to the seller. They're a neutral party. They're not allowed to be able to do that. So if both parties can't agree to the disbursement, they can send an interpleader. And guess what happens then? Well, a lot of times the title company can charge $25 fee a month. They can also have maybe the attorney start collecting fees. So, for example, let's say you have $5,000 to $10,000 as an EMD. The money gets interpleaded. The escrow company charges attorney fees, and such fees could range from $5,000 to $10,000, the actual amount of the EMD. So you're left with leaving the parties with nothing. So what I'd say, from the words of Willy Wonka, roll it.
It's all there, black and white, clear as crystal. You get nothing. You lose. Good day, sir. It's all there, black and white, clear as crystal.
Well, there you go. Right from the direct words of Willy Wonka. Special guest today. So, what did we learn to sum things up? If you have something in writing, you'll have a good chance of winning your claim against the other party in a small claims court if it's less than $6,500 or less, or otherwise you really need to hire an attorney for larger amounts. Even though the PA might spell out how to release the funds, the escrow agent or company might have their own requirements to release the escrow funds. Having language predetermining the release can help, but it doesn't guarantee the release. The escrow agent or company will probably have their own, again, internal documents that both parties must sign before those funds can be released. Remember, the escrow holder is not required to determine who is entitled to the EMD in the event of a dispute. That's why most PAs have a provision that the escrow agent may file an interpleader action. Therefore, unless both parties can agree, the money will sit with the escrow company until interpleaded. It's supposed to be no more than 3 years. Realtors should understand that title companies are not subject to the requirements of Article 25 of the Occupational Code, and may have their own rules as how funds will be held and under what terms they will be released. So many title companies will have their own forms, again, that both parties will have to sign in order to have such monies released. And again, this concludes our episode of The Deal Doctor and the non-refundable EMDs, unless we have any questions. Really, I just kind of wanted to make your head spin a little bit with a lot of language on EMDs that were non-refundable, so that we know that there's seriousness within this topic, and it's not as simple as, hey, can you write a quick clause for me? There's nothing quick about non-refundable EMDs, and they can be very challenging about writing the proper EMD to support and recommend or support your client appropriately. Again, we'll get these notes sent off to all agents later today. But other than that, I wish you a great day. This is Eric Graham signing off.